All rise, we will obey. The International Criminal Court is now in session. Lord John de Co Penal International at Uwait. Please be seated. We will also.
Ok, c'est fine. Bonjour à tout le monde, Madame la greffière.
Good afternoon to everybody. Madam Courtroom Officer, could you please call the case?
Good afternoon, Madam President, Your Honors. Situation in Libya in the case of the prosecutor versus Khaled Mohammed Ali El Hishri, case reference ICC 0111-0125. And for the record, we are in open session.
Merci, je souhaite la bienvenue.
Thank you. I would like to welcome everyone inside and outside of the courtroom. And I'm now going to ask the parties to introduce themselves, starting with the Office of the Prosecutor. Madam Prosecutor, please.
Good afternoon, Your Honors. For the prosecution today are Mr. Hashem Morad, trial lawyer, Mr. Renz Vanderwerf, trial lawyer, Ms. Jessica Lacey, case manager, and myself, Nicole Sampson, senior trial lawyer.
Merci. La Chambre vous remercie.
Thank you very much. I would like to now call upon counsel for the defense to introduce themselves.
Thank you, Your Honor. Today, the defense team contains of Mr. Ian Edward and myself, Yasser Hassan, lead counsel. Thank you.
Merci, maître.
Thank you, counsel. I'd like to now turn to the Office of Public Counsel for the victims to introduce themselves. Thank you, Madam President. The Office of the Public OPCV is represented by myself, Sarah Pellet, and Tars van Ditsenberg this afternoon. Thank you.
Merci beaucoup.
Thank you very much. We'd like to thank you, and we'd like to ask the representatives of the registry to introduce themselves. Thank you. Good afternoon, Madam President, Your Honour. For the registry and the OPCV, Natasha Schauder.
Merci.
Thank you. Today's hearing is the first status conference in this case. The main objective being to ensure that the inter-parties exchange of information is conducted in a fluid manner and in good conditions ahead of the confirmation of charges hearing. And I would like to remind you that the commencement of said hearing is set at the 19th of May 2026. The agenda for our hearing today has been communicated to you via email. And before handing over to the parties on the first point of today's agenda, I would like to raise a brief technical point. Our colleagues in the interpretation booths need for us to speak slowly, but especially we need to observe pauses of at least 5 seconds in duration before we speak. And I'm going to try to hold myself to that too. So the first point on today's agenda is the completion of the OTP disclosure process. Madam Prosecutor, over to you.
Thank you, Madam President. The prosecution, as we have indicated in our written submissions, is proposing, jointly with the defense, that the disclosure deadline for the materials upon which the prosecution intends to rely at the confirmation hearing be set for 19 March. Bearing in mind the limited scope of the confirmation hearing and the fact that we are focusing on disclosing items of true relevance to the factual allegations and the legal elements that we're required to prove. We have to date been in accordance with the Chamber's orders, disclosing to the defense and making required applications in relation to materials relied upon by the Chamber in the arrest warrant. And that disclosure process will be completed by 5 February. We have gone beyond the strict set of materials relied upon by the Chamber in the disclosures to date. And we have included not only the items relied upon by the Chamber, but also related items and some items that have been included in the arrest warrant application, but not relied upon by the Chamber in the warrant. To date, we have disclosed 1,296 items of evidence, which are classified as materials that we intend to rely upon for the confirmation hearing, materials that fall under Article 67.2, and materials that fall under Rule 77. And we will continue to disclose items up until the proposed date of March 19. We have been addressing 4 categories of information as we assess our collection. As I've already mentioned, we've been reviewing the arrest warrant materials relied on by the Chamber, the arrest warrant application submitted and relied upon by the prosecution. We've looked as well at documents, or we are looking as well at documents that are responsive to keyword search terms in both Arabic and English. And finally, we have as well some supplementary investigation that has been ongoing since the arrest warrant application. And we are assessing the items of evidence that have been collected in accordance with those investigations for immediate disclosure to the defense team. We do not anticipate that focused additional investigation would in any way hamper the start of the confirmation hearing. I wish to note as well that to date we have had excellent communication with the defense team in inter partes disclosure. If there are issues, the defense has come to the prosecution and we've sought to resolve them ourselves. Subject to any questions you may have, and bearing in mind, of course, that we have a precarious security situation that we're attempting to monitor and fulfill our obligations under the statute for the protection and well-being of witnesses, we do anticipate that we will be applying to the Chamber for the non-disclosure of information that is relevant for the Chamber's approval in advance of the confirmation hearing. And we will abide, of course, by the deadlines that Your Honor set for the final requests to be made, bearing in mind that we will simultaneously disclose any items for which we request non-standard redactions to the defense. And it is our proposal that the final disclosure deadline for such application be set for 19 March in relation to the items for which we wish to rely upon for the confirmation hearing. So from our perspective, Your Honors, the disclosure is in hand and we are set to review materials and handle disclosure for the confirmation hearing date. Thank you.
Merci beaucoup.
Thank you very much. We have a little bit of a situation with the lighting, but I'm sure it's going to be solved immediately. I'd like to say that the Chamber thanks you. And now, if possible, we'd like to hand the floor to the defense. Counsel, if you can speak under such conditions, it would be a good thing. Otherwise, we'll wait for the light to return.
شكرا سيدة الرئيس.
Thank you very much, Madam President.
شكرا سيدة الرئيس.
Thank you very much, Madam President.
أود بداية
At the outset, I would like
بمقدمة صغيرة
to give a small introduction
في هذه القضية وإذ
regarding this
قبلت الدائرة
case, and if the Chamber accepts and approves, there are some requests or maybe some clarifications
أن يوصلها
that my client would like to convey to you. So please, if you allow me, I would like to respond first, but then I can start with the requests. Can I start?
Yes, you can start, Council. You can start, Council. In the order that you have just mentioned. Yes, thank you very much.
شكرا سيدي.
Thank you very much, Madam President. To start with, I would like to thank the court for allowing us to speak Arabic. And I am aware that this is the first time Thank you very much, Madam President. I would like to thank the court for allowing us to speak in Arabic. And I am aware that this is the first time ever that the ICC is allowing Arabic to be used. This is not only important, but it is also necessary, extremely necessary for many reasons. First, Arabic is the only language spoken and understood by the suspect. Arabic is also the language of the entire Libyan people, and that people has the right to understand the facts and to understand what is being discussed here. Third, this is the first case before the International Criminal Court regarding the situation in Libya where the suspect is present in the courtroom. It is very essential that each person expresses themselves in their own language, because this is better for the speaker and also gives better possibilities to communicate the meaning be expressed, and it is to achieve justice. But there is another reason for giving my thanks to the distinguished chamber, is that I am the first person who can litigate in Arabic before the International Criminal Court. Well, actually, I was the first one to litigate in front of an international court or tribunal, and I mean here the Special Tribunal of Lebanon. And that's why I would like to thank your distinguished panel and the registrar for allowing me to do so. In fact, since Mr. Al-Hishri was transferred to this court, he's been wondering why I am here, why I am a suspect, what is the evidence against me. And until this point, the Office of the Prosecutor has disclosed 36 testimonies or statements in this case. 12 of them only were translated into Arabic, which means that the suspect is unable to read these statements, because at the end of the day, we, the defense team, have to work according to what our client is saying. So he can say, yes, I know this person, or I don't know this person. So the fact that we don't have these statements in Arabic is actually a real obstacle in the face of the defense team. But also the fact that many of these documents are heavily redacted. Not just that some basic information are redacted, but in fact most of the information, or the important information, is redacted. And that's why it is very difficult for us to work, and that's why we have requested before that these redactions are removed so that we can actually do our job and defend our client. So this disclosure the disclosure procedure that the OTP is actually talking about, yes, it did happen, but it didn't happen in a sufficient way that gives us enough information for us and for our suspect to understand what is happening in this case, because at the end of the day, he cannot understand English and he does not understand the technical evidence. And we were presented also with a technical evidence that needs an expert to explain to us, because we really need to understand how such evidence was analyzed at the end of the day. To that point, we were not presented, we were not given all the scientific evidence and reports that the OTP relied upon in order to analyze their evidence. But because we have already drafted a joint document with the OTP to organize the procedure of disclosure, we're not going to repeat what we said in such document again, but we would like to just reiterate that all the disclosed documents must be translated into Arabic so the suspect can understand what is written in such documents and understand their position. Mr. Khalid Al-Hishri, from now until the confirmation of charges hearing, is intending to challenge the jurisdiction of the court in trying him. He believes that he is not a subject to the Security Council resolution of the 1971, and accordingly, we are going to submit a written document with that, and based on the judgment of this court, the appeal chamber in the case of Al-Sanusi, and the number is, the reference number is ICC 01/11-01/110A6, established by the judgment. So we are going to rely on the judgment of the appeal chamber, which dropped the ICC's jurisdiction over Libya after the events of 2011. We are going to rely on this judgment, limiting it to a specific period of time and acts of a special nature. This is despite our knowledge of the issuance of Mr. Al-Dibaiba's decision on the 12th of May 2025. Mr. Dibaiba, who was Prime Minister of the situation in Libya, and that's why we have already submitted an appeal before the Libyan courts, given the fact that it is against the constitution in Libya.
Constitution of 2011, as well as all its amendments. Third, this ratification did not come from the Presidential Council of Libya, which is entitled to ratify international agreements. And we will be supporting our right to challenge this, and we will also communicate with the Libyan authorities to make sure that they did ratify or authenticate this about the extension of the jurisdiction of the International Criminal Court until 2027. Moreover, we will be waiting for the independent professional Libyan judiciary decision in case number 452 of the year 2025 before the administrative department of the Court of Appeal of Tripoli, and it was instigated by the brother of the suspect. And Mr. Khalid al-Hishri in person will participate in this case, and it will be about that this agreement is null and void. And here I have to point out that the Libyan judiciary is the owner of the jurisdiction, and it has proven its desire and its ability to try Libyan citizens that are present on the Libyan territory on the same criminal articles attributed to my client, Mr. Khalid al-Hishri, and that is by arresting and prosecuting Mr. Osama Najim upon his extradition from the Italian authorities, and he is now under arrest and pending trial in Libya. The same situation, the same accusation, the same legal situation applies. So there is a difference here and differentiation. Khalid al-Hishri is being tried here in the International Criminal Court, and Osama Najim is being tried in Libya. At a time when Mr. Dabaibi himself, the Prime Minister of Libya, is supervising all this. So this is discrimination by the law. And here we ask Madam Abdurrahman, who is the Minister of Justice, whether her ministry is capable and willing to try Libyan citizens. We have to ask her also whether the government of Libya differentiates between Libyan citizens based on their legal situation or not. We will also refer to the Presidential Council, especially Mr. Muhammad al-Menefi, who is the head of this council, in order to get his testimony on whether he had ratified the agreement of the said agreement or not, because he is the only one who is entitled by law to sign on behalf of Libya. Therefore, this agreement signed by Mr. Dabaiba is void and null. Madam President, Madam Judges, I can say confidently that the ICC law allows every Libyan citizen to appeal Mr. al-Dabaiba's decision of the 12th of May 2025 in order to extend the jurisdiction of the ICC up until the year 2027. Only one person cannot appeal this. Who is this person? It is Mr. Dabaiba in person. Mr. Dabaiba, personally, if he comes and sits here instead of Mr. Khalid al-Hishri to face the accusations that are given to him on war crimes and crimes against humanity that were perpetrated in Libya on the same day of the signature, and that is the 12th of May 2025, when hundreds of people were killed and injured. So this happened in Tripoli, and again, this resulted in the death and injury of hundreds. So, Mr. Dabaiba's signature on this agreement can only be understood that him personally is acknowledging and accepting the jurisdiction of the court on himself, and based on these facts. Madam President, despite the cut in the electricity, I can continue. Mr. Khalid al-Hishri has also asked us to submit a temporary release to the chamber. And in fact, we have submitted this application, and it's not adequate to talk about their details right now, but this application has gone through the appropriate legal and judicial channels. Mr. Al-Hishri has also asked me to convey his message to the court. And he says that he adheres to his legal rights of the presumption of innocence and upholds his innocence. And he objects to everything that's claimed by the prosecutor's office. He said, "I did not kill anyone, I did not rape anyone, I did not torture anyone, and I was not accomplice or a conspirator in any criminal acts that happened in Libya. I was a diplomatic employee in the Libyan government, and I was arrested while I was carrying a diplomatic passport." Mr. Al-Hishri and his defense will face all the evidence presented against him in this courtroom. Madam President, I have reached the end of my pleadings for now in this session, but I would like to confirm that the current procedures are ongoing, and we will be continuing our work. We did not request to postpone the confirmation of charges session, and we did not request any additional time for this, under the condition that the Office of the Prosecutor would abide by the deadlines based on the conditions that would allow also the Defense Counsel to do their work on behalf of Mr. Hishri. Thank you.
Merci beaucoup, Maître.
Judge Motok, thank you very much, Counsel, for your submissions. And I would like to say, first and foremost, that on behalf of the Chamber to Mr. Ahad El-Hishri, who is with us here today, I do have a question to put to the prosecutor first and foremost, as to whether you think that you will be translating the documents into Arabic that have not yet been translated, and if so, up to what date? How long would it take?
Thank you, Madam President. Yes, of course, the prosecution has an obligation to translate under Rule 76.3 statements upon which we intend to rely for the confirmation hearing. And as the Chamber is aware from a communication made by the prosecution to the Chamber last week, those translations are ready, but in transposing redactions, which have been extensive in the last series of 17 witnesses, a number of the redactions into the Arabic translations needed a bit more time, but they will be completed within the time frames set by the Chamber for disclosure to the defense. And the defense is in possession of the English materials at the moment, which allows counsel who understand and speak English to review the material, prepare as needed, and consult with their client. But we do not intend to hold back on the disclosure of the translations for any considerable period of time. They are nearly ready. If I may also address a few of the other matters raised by defense counsel. Some of the issues have not been anticipated because, of course, despite consultation and a joint submission on the agenda items, they were not included. However, on jurisdiction, I will only say that we will wait, of course, and respond once we receive the submissions. We are grateful for all the advance arguments that we can start to prepare already. The Al-Sanusi Appeal Chamber decision, as the court is aware, related to admissibility and not jurisdiction. However, perhaps the defense also intends to raise an admissibility challenge, but I have not to date heard that. In relation to redactions, the Chamber is seized now of applications for non-standard redactions, which are appropriate and permitted under the statute, in relation to the court's obligation to protect the well-being and dignity of witnesses under its care. In relation to the forensic item, it's an item that belongs to Mr. Al-Hishri. We assess he's quite familiar with its content. It was obtained in a collection for which the Chamber and the defense are aware. We do not intend to bring expert forensic evidence in relation to that item, but of course the defense is welcome to do so should they so wish. Thank you.
Merci beaucoup, Madame la Procureure.
The presiding judge, thank you very much, Madam Prosecutor. Regarding the applications or requests made by the defense, the Chamber takes note of your submission regarding your possible application challenging the jurisdiction and admissibility of the case. The Chamber recalls that pursuant to provisions 2, 3, and 4 of Rule 58 of the Rules of Procedure and Evidence, the Chamber shall decide on the procedure to be followed and may take any appropriate measures for the proper conduct of the proceedings in the event that such an application is filed. So I'll go back to you, Defense Counsel. Are you able, regarding the next status conference, to propose to us a provisional date for the submission of such an application?
مؤتمر تحضيري القادم أن أقدم تاريخا محتملا لكل طلبات الدفاع.
In the upcoming conference, I can give you a provisional date about this submission.
Merci beaucoup, Maître.
Thank you very much, Counsel. We were trying to cross-check whether we have received your application for the interim release of Mr. El-Hishri, but it is not yet in the system.
شكرا سيدة الرئيس. هذا الطلب تحت التحضير، ولكننا بدأنا إجراءات تواصل دولية فعليا، لأننا لا نريد أن نقدم طلبا كتابيا وخطيا إلا بعد الحصول على مستندات خاصة. هل من المطلوب أن أكرر ما قلت أم أستمر؟
Thank you, Madam President. Concerning the interim release application, we have started drafting it. However, we have to receive some documents before submitting the written application to the Chamber, because there are some matters and some details that we cannot disclose here in this session. And if the court orders us to do so, we can move to a closed session in order to disclose this and these details. However, the written application will be submitted anyway.
Je comprends, Maître, que vous
The presiding judge, I understand that you want to go to a closed session. Is that correct, Counsel?
No, Madam President, unless you request to have some specific details that we cannot disclose.
Non, merci beaucoup, Maître.
Judge Mutok, thank you very much, Counsel. We do not need to do that. We will be waiting for your written application. The Chamber is satisfied by the efforts made by the parties in order to bring joint proposals on these issues, and the Chamber sets the date of 19 March 2026 for the completion of disclosures by the OTP. The Chamber also confirms that it would be necessary to follow the approach and the format for the disclosure proposed in paragraphs 4 and 10 of the submissions number 53 in the case file. I will now move to the next point. That is the second point of our agenda, the proposed deadline for filing before the confirmation of charges. Madam Prosecutor, I will give you the floor first.
Thank you, Madam President. In relation to the relevant deadlines for the document containing the charges, the pre-confirmation brief, and the list of evidence, and any Rule 78 disclosure, the prosecution has proposed the 26th of March, which still allows more than 50 days to the defense team to prepare for the confirmation hearing. We do not anticipate currently filing any pretrial motions. We will respond to any, of course, that we receive. And we are requesting the 120 pages for the pre-confirmation brief that is set out in Regulation 38(1)A of the regulations of the court. Those are our submissions on that agenda point. Thank you.
Merci beaucoup.
Presiding Judge, thank you very much. We will now hear the observations of the defense on these points. Counsel, you have the floor.
شكرا سيدة الرئيس.
Thank you, Madam President. We are committed to the deadlines that we had set in our joint application, and we are waiting for the Office of the Prosecutor to submit all what they are bound by the law to submit within the identified deadlines.
Merci beaucoup.
Presiding Judge, thank you very much. The Chamber approves the joint proposal of the parties regarding the DCC list of evidence and the pre-confirmation brief. The deadline for this is the 26th of March 2026. Having taken into consideration the current schedule and the respective obligations of the parties, the Chamber will set the deadline for the disclosure of the possible witnesses to appear. Viva voce in the confirmation of charges hearing. That deadline is the 19th of March 2026. Regarding the disclosure by the defense of any evidentiary items pursuant to Rule 78 of the Rules of Procedure and Evidence, the Chamber sets the deadline of the 9th of April 2026. That is 3 weeks after the completion of the disclosure of the prosecution evidence. The Chamber would like to receive all written notes and observations from the defense relating to factual and legal elements, including grounds for excluding criminal responsibility and or raising the existence of an alibi by the 16th of April 2026 at the very latest. And that is 3 weeks after the filing by the prosecutor of the DCC and the pre-confirmation brief. The Chamber takes note of the other submissions of the parties, both written and oral. We will follow closely the evidence disclosure process by the prosecutor, and we shall set further details as appropriate for the purpose of ensuring the proper conduct of the proceedings in due course before and after that hearing.
Le troisième point à l'ordre du jour
The third point in our agenda,
à la demande des parties,
at the request of the parties,
le protocole
it is the
relatif à la
protocol
double qualité,
addressing the dual status witnesses,
soit celle des victimes
that
et des
is,
témoins.
individuals who are both witnesses and victims.
Je donne à nouveau la parole
Once
à
again,
Madame
I would like to give the floor to Madam Prosecutor.
Your Honor, the prosecution has proposed that the Chamber adopt the dual status protocol at the confirmation hearing phase, potentially the same dual status protocol that was adopted in the Abdelrahman trial. And we ask for it because the Chamber has already approved the procedure for admitting victims into the proceedings. We know that it is likely that victim applications will be processed in accordance with the ABC procedure before the confirmation hearing. We also know that the profile of many of the prosecution witnesses are crime-based, and therefore there is a likelihood that some of the applicants may be dual status. In our view, because the dual status protocol regulates communication and notice between the parties and the legal representative of victims, in order to permit the fullest of the exercise of the rights that the victims have to participate in the proceedings, then the protocol, if it were in place, could ensure that from the earliest stage possible, we are all informed of who may have a special status as a dual status witness, and that the legal representative of victims, in this case, and at least for this part of the case, the Office of Public Counsel for Victims, can meaningfully represent, and the victims can also fully participate and present their views and concerns within this confirmation hearing. Thank you.
Merci beaucoup.
Judge Motok, thank you very much.
Je me tourne vers le Conseil de
Now
la
I
Défense.
turn
La parole est à
to
vous, Maître.
the Defense Counsel. You have the floor, Counsel.
شكرا سيدة الرئيسة.
Thank you very much, Madam President. No, we don't have any legal position right now.
Merci, nous aimions maintenant
Judge Motot,
entendre du représentant
thank you very much.
du
Now
bureau du
we
Conseil
would like to
public,
hear from the
pour les
representative
victimes.
of the Office of Public Counsel for Victims.
Merci, Madame la Présidente.
Thank you, Madam President. To add to what has been said regarding point 1, in pursuant to the decision of December 2025, we received the disclosures of the 1296 documents. Now, I'll come back to this dual status issue because it directly concerns the interests of victims and potential victims. We also wish to state that its adoption immediately is not only appropriate at this stage, but is necessary to preserve the integrity and fairness of the proceedings. My colleague of the prosecution referred to the example that was adopted in Annex 2 of document ICC-01/14-01/18-677. So this model is of interest to us because it relates to contacts and communication with witnesses of dual status individuals. It is important because it does not govern anything more or less than this communication. Madam President, Your Honors, the adoption of such a protocol at the pre-trial stage is part of the obligations of the court, the judges, the parties and participants to protect the security and welfare of victims and witnesses. Article 68(1) of the Rome Statute. These obligations cannot be deferred to the possible trial stage, but they are applicable at the pre-trial stage, as stated by the prosecution. They are particularly important for the security, given the security situation. And there is also the report of the registrar submitted last week, paragraph 6, number 0111012556. So it contributes to the global fairness of the proceedings by staging, or rather establishing, a clear, protective, and predictable framework at the pre-trial level. On the other hand, Madam President, Your Honors, the coherence of the proceedings requires that comparable guarantees should be applicable as from the pre-trial phase and not only possibly to the trial phase. The judicial security and the predictability of the proceedings requires clear rules that are applicable, and that is more so because the pre-trial is characterized by great fluidity of the rules and interactions between parties and participants. In the absence of a clear framework, there is a risk of uncertainties and divergent practices, which are prejudicial not only to the integrity of the proceedings, but also the protection of victims and witnesses. And Madam President, going on to my third point, the reasons justifying the adoption of the protocol of a protocol mutatis mutandis during the pre-trial phase are actually more important, considering that the constitution of the case file involves the initial contacts with victims and witnesses, and therefore there should be a clear separation of roles to the benefit of the concerned persons, that is, the people that may benefit from dual status. I would like to also point out, Madam President, that the fact that such protocols have actually been adopted late in other previous cases in the court was a procedural matter and not any judicial constraint, and it could be an obstacle. As the prosecution has said, the people that might benefit from dual status have not yet been identified, cannot justify a delay in its adoption. The dual status of victim and witness is a situation that is predictable and which is frequent before the court. And the issue is not whether it will arise in this case, but when. The process of recognition of status of victim shall take place at the pre-trial phase, and therefore we would insist that witnesses may be granted the status of victims, and also and that will be my last point, the pretrial phase is not limited to the activities of the prosecutor and the defense. The legal representatives for victims also play an active role involving early interactions with individuals that might have dual status, and in the absence of clear guidelines, these interactions are exposed to preventable uncertainties. The adoption of such a protocol immediately would make it possible not only to harmonize practices, but also to ensure the judicial security of participants as well as their protection. And for all those reasons, we respectfully request that the protocol addressing dual status witnesses should be adopted immediately. Thank you, Madam President.
Merci beaucoup, Madame.
Thank you very much, Madame Pelé. And now I will give the floor to the representative of the Victims Protection Unit, if you have something to add. Madam Schauder, thank you, Madam President. We have no specific observations. The protocol clarifies the actions of the parties in relation to protected, including when they have to deal with protected victims, and considering that it is beneficial because it allows for a coordinated action, particularly with regard to security. The unit is available to the parties and representatives of the victims relating to issues with witnesses and victims. Josh Mutok, thank you very much. The Chamber is satisfied that the arguments of the parties and the OPCV are valid. The Chamber is of the view that the adoption of such a protocol shall facilitate and clarify the procedure to be followed for the exchange of information concerning as well as contacts with dual status individuals, that is, who are both victims and witnesses. This is a well-settled practice in the jurisprudence of the court. On this point, as you are well aware, and the provisions of the protocol have now been standardized. The Chamber instructs the registry to tender a copy, that is before the end of the week, a copy of the said protocol for reference. The fourth and last point of the agenda relates to the joint designation of experts. The Chamber is of the opinion that inter partes consultations for the purpose of the joint designation and instruction of experts will make it possible to facilitate the work of the court in anticipation of a possible trial. I would therefore like to know, on the one hand, if the prosecutor is considering preparing expert testimonies in case of a trial, and on the other hand, your position in relation to an inter partes exchange upstream. That means before their possible designation and instruction. Madam Prosecutor, you have the floor.
At this time, the prosecution does not anticipate calling expert evidence for the confirmation hearing, But if the charges are confirmed, we will seek to call expert evidence for trial. However, we are also very much open to consultations with the defense with a view to joint designation and instruction of experts. In particular, should the defense have any that they wish to call at the confirmation hearing, and potentially very early discussions in relation to trial-related experts. Thank you.
Merci beaucoup, Madame.
Judge Motok, thank you very much, Madam Prosecutor. Counsel, on this issue, would like to have your opinion. You have the floor, Counsel.
Thank you very much, Madam President. When the time comes to appoint experts, and when the prosecution presents the matter to us, we, of course, will be open to discuss the situation. We will have consultations with Mr. Al-Hishri and follow his instructions and see if we can accept to work together on appointing experts or not.
Judge Motok, thank you very much, Counsel. At this point, the Chamber would like to encourage the parties to consult themselves on this issue with as objective, that is, if the OTP is considering producing expert reports, to reach an understanding on the instructions that they should give those experts. The Chamber should report to the Chamber on this point on their advancement in these submissions, during their submissions prior to the next status conference. We have dealt with all the points on our agenda. Before we close, the Chamber would like to set a date for the next status conference. It will take place on the 3rd or the 4th of March 2026. And once again, the parties need to consult and file joint submissions to the extent possible on the 23rd of February 2026 at the very latest. These submissions would make it possible to report to the Chamber on the disclosure process and more generally on their preparations in anticipation of the confirmation of charges hearings. We also ask the Chamber, or rather the parties, to identify any issues or items that they would like to have included on the agenda of the second status conference. Unless there is anyone who wants to take the floor right now, we have now come to the end of our session. I would like to thank all the participants, the AV team, the interpreters and court reporters, the security officers, and all of you. Court is adjourned.
All rise, we will obey.